Morning, Judge.
Good morning, Mr. Manning. Claimant's not in with the next minute, so I'll call him. He's
Okay.
both dialing in. Right, I'm going to call him. It's Judge Murphy. Is this Robert Thomas Layer?
Yes.
Okay. All right, folks, we're officially starting the hearing at this point in time. Anything heard on the recorder prior to this point in time is not part of the record. This is case number 1 on the calendar, WCB number 20500126. This is Judge Murphy speaking. Everyone note their appearance for record, starting with the calendar, then I'll speak directly to the claimant. When you're not speaking, please mute yourself. Go ahead, Mr. Manning.
Robert Manning for New York Petroleum at General Utilities, care of Glacier Bay.
Okay. Mr. Lair, can you hear me? It's Judge Murphy.
Yes.
Do you have an attorney?
No, not yet. I mean, maybe, but maybe by the end of the week.
All right. We still have to go forward with the hearing. All right, sir.
An adjournment they told me to try and get. I talked to somebody yesterday, and it wasn't really enough notice.
Who did you speak to?
My father, he's at Local 3. He said maybe one of their guys help me out.
So you spoke to your father yesterday,
Yes.
and you knew the hearing was today.
Well, he was in a coma for 4 days, and he was in the hospital for 10. So it's one of those things, you know.
Did you sign the HIPAA release?
Oh, I still have the appeal going.
It doesn't matter, sir.
Oh, it does matter. You're not allowed to overrule the appeal.
No,
You don't have the authority to overrule the appeal.
the appeal is nothing, sir. All right.
Nothing?
I swear you win, and we're going to go forward. All right. Can you please,
I still have a lawyer.
please state your name for the record?
Robert Layer.
These are legal proceedings. I have to swear you in. I have to confirm who you are. And your date of birth, please.
What was it?
Your date of birth, please.
February 26, 63.
And the last 4 digits of your social security number.
4046.
And your address, please.
122 Bayberry Lane, Levittown, New York. 1175.
Okay. Based on the information supplied to me by the speaker on the phone, I believe him to be the claimant. All right, sir. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I always tell the truth. It's the other guys you have to worry about.
It's a yes or no question, sir.
What?
It's a yes or no question. Do you swear or affirm
I always tell the truth.
the truth and nothing but the truth?
I always tell the truth.
Thank you. And are you under any medication, alcohol, or drugs that may affect your ability to understand what's going on at today's hearing?
I guess, yes.
Okay. Now, your telephone number I called you at today was 516-597-5658. In our file, we list 516-312-5658. 5352. Which telephone number do you prefer we use?
For right now, or
For in the future, when we need to call you.
the 312 number?
Okay. And you don't have an attorney, is that correct?
No. I am forced to not have an attorney.
All right, Mr. Manning, you can unmute. You have
Yes,
any?
Judge.
Mr. Manning. I'll
Right.
mute myself. Go ahead.
Oh, Judge, a couple of things. First, I just wanted to note for the record that pursuant to Title 12 of the New York Code of Rules and Regulations, Section 300.9 C, as in Charlie, it is our contention, it is improper for anybody to record these proceedings other than the Workers' Compensation Board. In addition, Judge, we had filed an RFA 2 seeking to have all medical and indemnity benefits suspended in this case pursuant to Section 13A4 and Section 19, based upon the claimant's failure to comply with prior directions by the Workers' Compensation Law Judge and a board panel decision of February 2020 in regard to signing and providing a HIPAA release. The claimant has made reference to his having filed a notice of appeal to the appellate division, and we respectfully submit that the board rules and regulations are very specific, that the filing of same does not stay the proceedings, and that the failure of the claimant to sign the HIPAA and otherwise comply with the board panel decision in this matter is significant and serious enough that should warrant an immediate suspension of benefits. In addition, we would continue to seek testimony of the claimant concerning issues as it relates to the use of medications, as well as periods of reduced earnings, and what we submit going back several years, and the issue has not been finalized, issues whether the claimant had intentionally failed to provide us with information relative to a return to work.
What was that?
Hold on, sir, it's me. It's the judge. All right. I'm going again, note for the record that, hold on, it is inappropriate for anyone to record these minutes at all. Absolutely inappropriate. The only person can do that is the board.
What?
If you're taping, sir, or you're doing any kind of thing, it's improper. Do I make myself clear? Now, you want to address, are you taping this at all, sir?
I want to know what law he cited or whatever it was.
Sir, yes or no? Are you taping this hearing?
I'm going to look it up right now before I do anything.
Sir, are you taping this hearing? It's a yes or no question.
I'm not going to answer that.
Yes, you can. It's yes, I'm taping. No, I'm not taping.
No, I'm not answering it.
All right, sir. Did you file the HIPAA release? Did you sign the HIPAA release?
I have an open case with it. It's no different than what I have with the appellate court. It's the same as on page 9.
Is it the answer you have not signed the HIPAA release? Is that correct?
I have an open case. I'm appealing that.
Sir.
They abused it last time anyway.
Sir, appeals to the third department do not stay findings before the board. They stay in effect, their findings, until there's a finding by the third department to the contrary. It does not stay any of our findings.
I think you have it backwards. You can't overrule the appellate.
I'm not overruling them, sir. There's no a decision on this case by the appellate division.
That's not right. It's no difference. The appellate is no different than the Point 1. What was the case law number that you gave for the recording?
I'll
Judge,
mute myself.
Judge, this is Robert Manning. The section I cited and cited at the last hearing, as did Your Honor, is Title 12 of the New York Code of Rules and Regulations, Section 300.9C, as in Charlie. Judge, we respectfully submit. Judge, we respectfully submit We respectfully submit, Judge, that in light of the failure to have complied with prior requests of the board panel and Your Honor in regard to submitting the HIPAA documents, notwithstanding those directions, notwithstanding documents having been submitted into the board file seeking this information, including but not limited to correspondence dated November 2nd, 2020 under document ID 3490700723, 3490700723, that all proceedings should be suspended and together with medical indemnity benefits suspended. The claimant's failure to also respond to your questioning in regard to the issue of recording, Judge, I believe also adds to the outstanding issues in this matter.
What was the rules and regulations after that? What did you say? Title 12, New York.
Your Honor, this is Robert Manning again, and I will repeat. Title 12,
right,
of the New York Code of Rules and Regulations.
Okay.
It is generally abbreviated as 12 NYCR, as in Romeo, R as in Romeo, 300.9, paren, small c as in Charlie, close parentheses. 12 November, Yankee, Charlie, Romeo, Romeo, 300.9, paren, small c as in Charlie, close paren. Thank you, Judge. And Judge, I do apologize. It's Robert Manning again, simply because it is on the notice of hearing. There is reference to a C8.1B. There is one contained in the electronic case file under document ID number 340-520-325, which is a bill from City Med with the date of service listed as July 19th, 2019, and the bill having been submitted on or about May 5th, 2020. The C8.1B maintains that the medical report of bill for treatment was not timely filed or is legally defective insofar as it was not submitted within the time frame provided by the workers' compensation law and rules and regulations. Not quite, but almost a year later, 10 months later. Thank you, Judge.
I muted myself, Mr. Manning. You can mute yourself and I'll look at that. All right, Mr. Blair, you want to address the C8.1B dated May 8, 2020? Do I have a comment to make about that C8.1B? That's a disputed medical bill.
I couldn't get it.
All right, please repeat what you just said.
Wait.
All right. The C8.1B dated May 8, 2020 is found in favor of the carrier without prejudice to the medical provider resubmitting the bill with proof that it was timely filed or with a detailed explanation as to why it was not timely filed. By law, the claimant is not liable for the payment of this disputed medical bill.
What are you talking about?
There's a disputed medical bill in the file.
Oh, what? Under the e-case?
Yes. The medical provider filed it late. I'm finding in favor of the carrier until they can produce proof it was timely filed or a detailed explanation as to why it could not have been timely filed.
What date was that?
It's dated May 8, 2020. All right, sir. Did you sign the HIPAA release?
Wait, hold on. Let me do the 5-8 thing first. 5-8 MEDNRR.
I'll give you the doc. Are you accessing the e-case?
Yeah, I'm already on it.
All right, then I'll give you the document ID number. Hold on.
All right, I think I have it. 9989 is the last four.
It is 340520325. Received May 11, 2020.
Judge, this is Robert Manning.
Go ahead.
That doesn't identify the C8.1B. In addition, the medical narrative report of the doctor, document ID number 340449989, has a marked receive date of May 8th, 2020. As I said, 10 months later, which is in accordance with the information contained in the C8.1B. The C8.1B, Judge, as an issue is specifically listed among various other issues on the notice for today's hearing. Thank you, Judge.
You know, even though it's today's hearing, I have like 30 minutes period. Just remember that. You're forcing me to go close the case, and I have 6 to no experience.
Sir, you've had, let's see, when did Mr. Law firm of Gray and Gray just step off this case?
2018.
And I told you the first time you ever appeared before me to get an attorney.
Oh, this is what you said. I'm going to play it right now.
Well, I'm ruling on the C8.1B. The C8.1B I've ruled on. Now, did you sign the HIPAA release, sir? Did you sign the HIPAA release?
They don't want to touch the case because when they do a 110A, they see that you put in complaint against your former attorney, sir.
Sir, did you sign the HIPAA release?
They see that you've been had a dispute with your last law firm, well, no one's going to touch the case. Like, sincerely doubt there's going to be anyone touching your case.
Okay, you heard that, right? That was your voice.
Sir,
Judge,
That was the minute.
go ahead.
Recorded your company. And I even had somebody call Manning's office.
Sir,
I had a colonel call Manning's office, and they rejected it.
Manning is your defense attorney, is the carrier's defense attorney. They wouldn't take the case.
It wasn't me. I had some girl call that was similar. And they rejected it. So the case is over. Anything over 6 years, they don't want to.
Again, sir, you had the problem with your last law firm.
Yeah, there was no money left in the case, although it was fixed. I didn't want to settle.
Sir, I'm trying to tell you, I can't help you because you don't listen. You want to fight everybody. People just want to move the case forward. You have to be respectful. You have to be respectful for that. Sir, you want to put banners up on the outside of buildings with people's names, disparaging them.
Afterwards, after all that.
Sorry, I'm not going to argue with you. I'm not going to.
I'm agreeing with you.
HIPAA. Did you sign the HIPAA release?
It's under appeal.
All right. The answer is no. It's a yes or no question. Did you did you sign the HIPAA release?
I have a signed one, but it's under appeal.
Okay. Due to the claimant's failure to produce a properly signed HIPAA release, claimant's benefits are suspended. See the EBRB1 dated February 11, 2020. And other.
They already suspended them. They already withholding medicine. They already withholding my money. I swear, you guys are like a freaking Hitler, you know?
Myself, can you tell me, you guys,
take away
Mr. Manning?
It's Robert Manning. What was your question? I'm sorry.
Have you guys suspended his compensation?
Not to my knowledge, Judge.
No, it's on the You sent me a letter. You signed it.
I can't hear the claimant, Judge. I apologize.
Okay.
I have the letter right in front of me. If you want, I could even fax it. Oh, I can't fax it to you. I could email it to you. Signed by Robert Manning. It came actually a week before Christmas.
Judge, this is Robert Manning. Two things. I again repeat the fact that under 12 NYCRR 300.9C, the claimant is not, it is our contention the claimant is not to record these. We maintain that we believe he is in violation of that. The claimant does not have my permission to record me, especially in light of that. The claimant does not have my permission to reproduce any recording he may make on any type of media, social or otherwise. The claimant was served with a copy of an ERFA2. So we did an RFA2, Judge, requesting that benefits in this case should be suspended based upon the claimant's failure to comply with the direction of the law judge on December 11th, 2020. And you, Judge, and there were prior decisions, but you, Your Honor, on November 18th, gave him another 2 weeks, and he still did not comply.
I have until the appeal court answers. And you can't threaten me to sign it until they answer.
Judge, we respectfully submit that no threats have been made to Mr. Layer. I continue to repeat. It is our contention he does not have authority to record these proceedings. He does not have the authority to post any of this in regard to anything that I may be on any type of social or other media. In addition, we respectfully maintained it is our argument that the claimant may have filed a notice of appeal. His time for having perfected same has passed. The claimant has not received, notwithstanding documents he has noted as extensions of time, any extension of time. And Your Honor has already noted that an appeal to the appellate division does not stay these proceedings. Thank you, Judge.
All right, sir, I'm going to tell you again, and I'm telling you, you are not allowed to record these hearings. You are not allowed to take recording minutes. Clearly you did. Sir, you're not listening. Clearly you did. You're violating law. It appears that the claimant has recorded one or more of these hearings.
No, these are all from the DAR minutes.
Sir.
Digital audio recordings from workers' comp.
How did you play it back? Put on one of your own recordings. Is that correct?
They emailed me the recordings.
Judge, this is Robert Manning.
The next day, the day after, they emailed it to me.
Judge, this is Robert Manning. There is one indication in the board file of the claimant having requested a DAR. However, based upon the claimant's correspondence, in regard to the nature of his having done recordings, his refusal to answer your question specifically, while DAR is the only permissible recording under 12 NYCRR 300.9C, the claimant's own recording we continue to submit is not permitted.
Don't put words in my mouth. These are the words that count. All the recordings are from workers' comp.
Do you have it captured on something?
Yeah, they sent me an email. Once they send me an email, it's like a set tape.
All right. Due to claimant's failure to produce a properly signed HIPAA release, claimant's benefits are suspended.
They already are suspended. They suspended
February 11, 2020, and other 3-member board penalties.
They've already been suspended.
Okay.
They did it without you. They don't even need you. They're like their puppet.
Okay. Anything else, sir?
Yes. All right. I've had awards sitting there since 2016 for 5 years. I have 27, 48. I'll give you the exact amount. $7,592.47 from work from 2016 to July 27th. $28 weeks and 49 weeks at 98 and 98.61.
All right. I'm not sure what you're trying to tell me.
I'm saying I have awards due to me 5 years ago.
And you'll get no money until you file until the outcome of the third, or you file the HIPAA release.
So you do what I tell you. That's the way it is for you. This is what you did last time. You threatened me.
I didn't threaten you, sir. I'm just.
Hey, you're not getting any money until I sign. No, the money was 5 years ago.
Sir, you can either sign the HIPAA release or wait.
You have 14 that's it. You are the puppet.
Okay.
Nobody else. Judge Lawyer won't do this. Judge Khan won't do this. They manipulate you. You do whatever they want, like the little puppy dogs.
Okay. Anything else, sir?
Yeah, there's a lot.
Okay. But I'm a strict instruction. What is the law? Other people don't like following the law. Some people get intimidated when someone yells at them. I don't. The law is the law. Anything else before I say goodbye, sir? All right.
Yes.
Everyone,
$1,000 I laid out for medication.
again, you can wait until the third department rules on your appeal, or you sign a release.
This is just another way for them to withhold the medicine because they did it for 3 years. They bribed Dr. Perry, to write down what they wanted on the report.
Who bribed Dr. Perry?
Dale Baldwin. I took Dr. Perry to court and he told everything. They needed a report in the opposite of what I wanted. That's what they did.
And you have proof to bribe Dr. Perry?
Yes, I took Dr. Perry to court.
Evidence. Then you should have the evidence.
I do.
All right, you didn't produce it. All right, anything else, folks? All right, everybody take care and have a good day.
How come Judge Lerner won't do this? You're the only one that their ass like this.
Okay, anything
You're
else?
Howard. You only get really forced to a man doesn't have a lawyer.
Bye-bye. Bye-bye.
Cowards, when I had an attorney, you're a little bitch. But now I don't have an attorney, you're like a strong guy.
Yeah, okay. You have a good day, sir. All
When
right.
I had an attorney, attorney. You didn't do
Bye-bye.
anything. Now I have no attorney. You're like I said, a little deal.
All right. Bye-bye.